Hello, my name is Kyla Whitley, and welcome to my special education law presentation. Children with special needs and disabilities were denied adequate schooling until the 1970s. There were history of exclusion, isolation, abuse, and neglect that changed only when mandated by law. Going on into the 1970s is when opportunities were offered for the mental and physical handicapped children that no one ever dreamed of. That special ed system had evolved into what we have today. Special education in the United States now is a model of very best teaching practices with certification requirements for each area of disability using the best teachers in the field. Teachers are to model how to accommodate and provide the best services in the least restrictive, most appropriate learning environment. Special education is needed for students who have a disability that interferes with their ability to learn or their ability to communicate their basic needs and wants. Disabilities can be a physical, mental, or both. In America, every child has a right to a free and appropriate public education known as FAPE, no matter what their disability. Special education is tailored to each student based on where they are academically and or functionally. And here are a few categories recognized under IDEA, Individuals with Disability Education Act, which are emotional disturbance, hearing impairment, intellectual disability, deaf, blindness, and speech or language impairment. Which now brings me to a couple of court cases about parental rights and student educational rights. My first case is Board of Education versus Raleigh. A deaf child named Amy Raleigh was advancing grade to grade in least restrictive environment, LRE, with a FM hearing aid. Amy's parents requested the school district to provide Amy with a qualified sign language interpreter, where the district disagreed. Appeal after appeal. The court inquired under IDA has two parts. One, whether state complied with procedural safeguard of the act, and two, whether the child IEP is reasonably calculated to enable the child to benefit from an educational plan. The second case, Hanning versus Doe, was about expelling a disabled student named John Doe that was 17 years old and had challenges in his ability to control his behavior impulsively and anger toward others. The district wanted to expel him, but the court ruled that a school district may not expel a disabled child from the classroom setting for dangerous or disruptive conflict growing out of their disabilities. Because of the importance of school district following the procedural safeguards contained with the IDA, which includes the right to due process in an IPE meeting. Which brings me to some resources that would be helpful in keeping you updated while legal trend in special education. We have Missouri Department of Elementary and Secondary Education, Massachusetts Department of Elementary and Secondary Education, and last, Parent Center Federation for Children with Special Needs. I thank you for joining my special education law presentation.